Minister to make a statement on the findings of the inquiry into the National Security Council leak.
Chancellor of the Duchy of Lancaster, Minister for the Cabinet Office. Minister David Lilly.
Mr. Speaker, sir, the National Security Council takes critical decisions about keeping this country safe. It was established in 2010, in part following lessons learned from the Iraq War, to ensure proper coordinated decision-making across the whole of government. It operates with the full breadth of expertise in the room, with ministers from the relevant departments, advisers and officials, including the Chief of the Defence Staff, the Chairman of the Joint Intelligence Committee, the heads of the intelligence services and others. The decisions which it makes are of critical importance to the safety of British citizens and of British interests both in this country and around the world. For example, it is inconceivable today that the Cabinet could take a decision to commit combat troops without a full and challenging prior discussion in the NSC on the basis of full papers, including written legal advice, prepared and stress-tested by all relevant departments and with decisions formally minuted. And I'm sure that the whole House will recognise how important it is that those decisions are taken in an environment in which members of the Council and those who advise them feel free to speak their mind with absolute certainty that the advice which they provide and the conclusions which they reach will remain confidential. The leak investigation into the disclosure of information about 5G was constituted in order to ensure that the integrity of the NSC in general is upheld, and that vitally, participants in NSC meetings can continue to hold full confidence in its operation and the confidentiality of its proceedings. The Prime Minister has set out her response to evidence from the leak investigation last night and has thanked all members of the National Security Council for their full cooperation and candour during the investigation. The unauthorised disclosure of any information from government is serious, and especially so from the National Security Council. The Prime Minister has said that she now considers that this matter has been closed, and the Cabinet Secretary does not consider it necessary to refer it to the police, but we would of course cooperate fully should the police themselves consider that an investigation were necessary. Mr. Speaker, the House will recognise that it is the policy of successive governments of different political parties not to comment on the detail of leak investigations, and I will not comment on specific circumstances or personnel decisions.
Tom Watson.
The primary duty of any government is to keep our country safe and secure. On that, we all agree. This leak from the National Security Council is a fundamental breach of that duty. So let us be clear here. The Prime Minister believes her former Defence Secretary leaked information from the National Security Council. He vehemently denies it. Only one of these accounts is accurate. I don't think we have ever seen a leak from the National Security Council, and that's why this is so serious. The damning letter from the Prime Minister was a result of her understanding that to leak from that committee is an abdication of responsibility and public duty. It is indicative of the malaise and sickness at the heart of this ailing government. It is indicative of the sorry state the party opposite find themselves in. In response to receiving the most brutal sacking I can think of, the member for South Staffordshire has protested his innocence. Therefore, this matter cannot be, as the Prime Minister says, closed. The essential point here is that the Prime Minister has sacked the Secretary of State for Defence because she believes there is compelling evidence that he has committed a crime. But despite that, she does not believe he should face a criminal investigation. Where is the justice in that? In what world is it acceptable that the Prime Minister should be the arbiter of whether a politician she believes is guilty of criminal conduct in office should face a criminal investigation? Can he confirm that there were no leaks from the leak inquiry itself, given details seem to have been passed on to a national newspaper on the 30th of April? At the heart of this battle in the National Security Council was whether the Prime Minister's judgment that Huawei should be allowed to be part of our critical infrastructure network was sound. Many believe it was not. Our Five Eyes partners are so concerned about the UK allowing this company to participate in our 5G network that they are considering whether they can safely continue to share intelligence with us. The Minister will know that for the Americans and the Australians to raise public concerns on this matter is unprecedented. The Five Eyes network is the intelligence apparatus that has helped keep this country safe for nearly half a century. I know that. I've been a Defence Minister. I've seen the material we share with each other in total confidence. In his defiant challenge, the former Defence Secretary has put the Prime Minister's integrity and judgment in the spotlight. Whether he is guilty or not should be a question for the criminal justice system. The question the Minister has to answer today is he confident that the Prime Minister's decision to allow Huawei to participate in our 5G networks keeps this country safe and protects our intelligence relationships with our allies?
Mr. Speaker, the right honourable gentleman is eliding a number of different subjects in his questions to me. On the question of the substance of the government's policy decisions, it has been said from this dispatch box already on a number of occasions that the review of 5G networks being carried out by my right honourable friend, the Secretary of State for Digital, Culture, Media and Sport, is a matter of public record. The government has committed to telling this House of its conclusions once those decisions have been taken and approved at all levels within government, and we are ready to bring that information to this House. And that will be the time for this House to both learn what the government has decided and to hold ministers to account for their decisions. I can reiterate to the House, Mr. Speaker, that the government's priorities for the future of telecommunications remain stronger cybersecurity practices, greater resilience throughout telecommunications networks, and diversity in the marketplace. As has again been said before from this dispatch box, this is a policy challenge that goes beyond a single company or even a single country. We continue to work very closely with all of our Five Eyes allies and with other international partners. The problem about this particular case was not so much the question of the material that was disclosed, but the forum from which the leak came. And it was to maintain the integrity and secrecy essential for the proper conduct of the business of the government of the United Kingdom, whichever party happens to be in office, that caused the Prime Minister to set up the inquiry and to take the decisions that she took yesterday. The inquiry, as far as I am aware, took place on the basis of confidentiality throughout its proceedings. It came to conclusions that were reported to my right honourable friend, the Prime Minister, and she has taken the decisions that she announced yesterday. This boils down, Mr. Speaker, to what is set out in the Ministerial Code at paragraph 1.6, which states that ministers only remain in office for so long as they retain the confidence of the Prime Minister. She is the ultimate judge of the standards of behaviour expected of a minister and the appropriate consequences of a breach of those standards.
Sir Michael Fallon.
My right honourable friend agree that it is not only the work of our intelligence and security services that could be compromised by unauthorised disclosure, but also the Council's access to information and advice provided by our allies on a top-secret basis. And can he reassure us, therefore, that our allies have been reassured in turn that this sorry episode will not be repeated?
I mean, appropriate contacts are, of course, being made with our key allies, as my right honourable friend would expect. And he's absolutely right in the point that he makes. I mean, certainly I, like he, can recall discussions which involve not only the highest level classification material within the UK government system, but also the sharing of information disclosed to us in confidence by some of our key allies. And without going, for obvious reasons, into detail, if I could just remind the House, Mr. Speaker, that amongst the subjects discussed at the National Security Council in the last year alone have been our analysis of and response to the chemical weapons attacks in Salisbury, and our analysis of and our response to the civil war and conflict in Syria. I think members on all sides of the House will appreciate the importance of these discussions being remaining confidential at all times, and for all participants to have full confidence that will continue to be the case.
Stuart Malcolm Mcdonald.
Thank you, Mr. Speaker. This is a most disgraceful episode from the Right Honourable Gentleman for South Staffordshire, but fair play to the Prime Minister in acting as swiftly as she did. But I'm afraid it is not in her gift to say that the matter is closed. The fact we're here today shows that it's far from closed. I want to take the Secretary to the Prime Minister's letter. It says in here in the 4th paragraph that all the Cabinet Ministers that were interviewed had answered questions, engaged properly and provided as much information as possible. But the Right Honourable Member for South Staffordshire, his conduct had not been of the same standard. So what was his conduct? What exactly was he avoiding answering? And can I ask about the purpose of the investigation? Surely to God, it wasn't just set up to determine who the leak came from. Surely, when that is determined, there has to be a more severe consequence than just losing your position in Cabinet. If the integrity of the government, what's left of the integrity of the government, isn't going to be shot to pieces any further, then there has to be a much more severe consequence. So can he tell us, does the Right Honourable Member who has been sacked have a future in the Conservative Party? Will he be suspended from the Conservative Party? Will he be eligible for future candidacy within the Conservative Party? And will he have his CBE removed by the government as well? And finally, can the Secretary stand at the dispatch box and answer a very clear question? Has the Official Secrets Act been broken? Yes or no?
Minister.
On the terms of the honourable gentleman's final question to me, that is not a judgment which I or any other minister in any government can make. Whether a criminal offence has been committed is a matter for independent prosecution authorities and ultimately for the courts. I did say earlier, Mr. Speaker, that I'm not going to go further than has been set out already in the Prime Minister's public statements about the details of the investigation and its conclusions. I think that members on all sides of the House will recognise the history of very close working relationships between my right honourable friend, the Prime Minister, and my right honourable friend, the member for South Staffordshire. And that, I think, ought to persuade the House that the Prime Minister would not have taken the decision that she did were there not compelling evidence and no credible alternative explanation of what had happened. My right honourable friend, the Prime Minister, in her letter, did, as the honourable member mentioned, say that the conduct surrounding the investigation by my right honourable friend, the member for South Staffordshire, and his team was in contrast with the full cooperation experience in respect of other ministerial members of the NSC and their teams. And my right honourable friend came to the decision that she announced last night. In terms of the honourable gentleman's requests for sort of further punishments, obviously honours are a matter not for ministerial decision, but for an independent committee in any case. But I would just say to the honourable member that my right honourable friend, the member for South Staffordshire, has lost a job that he loved and to which he was utterly committed, and I think that should stand.
Mr. Dominic Grieve.
Thank you, Mr. Speaker. I entirely endorse the words that my right honourable friend used when he made his statement, and the absolute necessity that the working of the National Security Council be kept confidential, without which our allies cannot trust us, and indeed it would become impossible to discuss secret matters within government. Does he, however, agree with me that the problem we now seem to have is that we have watched a progressive breakdown of collective responsibility? And unfortunately, what appears to happen is it has a corrosive quality which starts in the willingness to contradict colleagues over policy issues within the Cabinet, and then creeps incrementally into a willingness to brief externally on discussions of an increasingly secret nature. And does he share with me the hope that if some good comes out of this most unfortunate episode, it's finally a shot across the bows for those who think that that is acceptable behaviour?
Minister.
I agree with my right honourable friend about the corrosive effect of unauthorised disclosures. I think, Mr. Speaker, we've all of us got to be honest with ourselves. I don't think there's been a government in history from which there have not been leaks, from which there has not been gossip from time to time, and I'm looking across at the front bench opposite. My mind goes back to what we saw under the Blair and Brown administrations. But I do want to say this in response to my right honourable learned friend, the member for Beaconsfield. I do think, above all when it comes to National Security Council discussions, but I think this applies in particular to Cabinet too, that I think there is great merit in the very old-fashioned precept that members should speak with complete candour within the room and shut up when they get outside.
Mr. Gavin Jones.
Thank you. The member who speaks for the SNP asked a very direct question, whether or not he thought the Official Secrets Act has been broken. The Minister in reply said that it was for others to decide. Can I ask whether the Attorney-General has been asked for his opinion, or any other legal advice has been sought by the Prime Minister to come to that conclusion?
Minister.
It's not a matter for the attorney either, for any other minister. This is a decision that has been taken on the basis of the lack of confidence that my right honourable Prime Minister regrettably came to feel in my right honourable friend, the former Secretary of State for Defence. And it followed the principles that I set out in quoting from paragraph 1.6 of the Ministerial Code.
Sir Oliver Letwin.
Thank you, Mr. Speaker. Having been somewhat involved in the establishment of the National Security Council in its current form and having sat on it for 6 years, I completely understand the Prime Minister's correct understanding that it has to be a sealed container if it's to do its work appropriately, as the Minister has said. But would he agree with me that, notwithstanding the rather brilliant confections of members opposite, actually on this occasion, thank goodness, so far as the substance is concerned, and regardless of its legal standing, which I accept is a matter for others to decide, actually there does not appear to have been a compromise of any classified information?
Minister.
Well, I think it's. I don't want to rush to make that assumption, because normally all papers that are considered by the National Security Council are at an extremely high level of classification. But the key point here, which is where I think the thrust of my right honourable friend's question, and I agree with him on this, is that the issue at stake here was less the substance of the material that was disclosed than the principle of a leak from the National Security Council itself. Because the fact of that leak, that breach of confidentiality having taken place, is what puts at risk the mutual trust which is essential for all ministers and advisers attending those meetings to have in one another, and also the trust, as my right honourable friend, the member for St Oaks said earlier, the trust that we expect our allies to have in respect to confidentiality of the material they share with us.
Mr. Alistair Carmichael.
Thank you, Mr. Speaker. The Prime Minister may or may not be right that, as far as the government is concerned, her exchange of letters yesterday is the end of the matter. But surely when it comes to matters in this House, different considerations apply. The Right Honourable Member for South Staffordshire and the Prime Minister are both members of this House. They have now got very different versions of events in relation to a matter of some national importance. And it is surely important that the House should know which of them is right. And for that reason, surely, either the Prime Minister has got to publish the evidence on which she lied, or else somebody else has got to be allowed to mark her homework. It cannot be possible that both of these mutually contradictory versions can be allowed to stand.
I have to say to the right honourable gentleman that what we're talking about here is a leak inquiry carried out on the instruction of the Prime Minister on behalf of the Cabinet Secretary by another appropriate official about the unauthorised disclosure of proceedings of the National Security Council. It is an internal government matter, just as any such disclosure, any leak inquiry would be considered a matter for the government concerned, Labour, Conservative or Coalition. And I really don't think it would be right to be in the position where the House collectively tried to establish itself as an investigating authority into internal matters relating to the conduct of ministers as members of the government or the conduct of officials as members of the government. Those are matters that it is quite proper for the government to determine, and for ministers then, as I am doing this morning, to come and explain the government's decision and be held to account by the House.
Justine Greening.
Thank you, Mr. Speaker. Having also sat on NSC for several years, I recognise how important it was that this leak inquiry was undertaken. But there's a broader question about the approach that both NSC and Cabinet need to take in order to serve the national and public interest. That's what's at the heart of this. And I think that I completely agree with my right honourable friend in relation to the NSC, but surely there's an element of this that does extend to how Cabinet is conducted and the rules around it and the behaviour of those who sit in Cabinet too. And isn't it now time to be clearer about the Ministerial Code of Conduct and the role of public interest in the briefings that are given externally? And the reason I say that is because on the one hand we have a freedom of information law that clearly sets a public interest test that is applied routinely by departments. And yet it does seem to me that those Secretary of States running those departments can routinely set that public interest test themselves without any regard for the way in which their officials would do it on a day-to-day basis, almost certainly excluding ever publishing advice to ministers to the public when they've asked for it.
Minister.
I would disagree with my right honourable friend on this point, that I think that ministers and their officials do take very seriously their duties to put the public interest first. That is absolutely central to the principles not only of the Ministerial Code but of the Civil Service Code, which, let us not forget, has statutory force, unlike the Ministerial Code. And in my experience in the last 9 years in government, these are principles that ministers take very seriously indeed, and their officials, particularly senior officials, are very clear and robust about reminding ministers about those duties. Where I agree with my right honourable friend is that I hope that there will be lessons learned from this particular episode about the importance of mutual trust and confidentiality of Cabinet proceedings.
Anna Soubry.
Mr. Speaker, for well-rehearsed reasons, this is clearly an extremely serious matter, and it's made worse. It's aggravated by the fact that the source of the leak was the Secretary of State for Defence. Mr. Speaker, many people believe that this really does mark the complete disintegration of this government, where some, and I emphasise some members, just have completely swept aside any scraps of decency and honour in the pursuit of blatant personal ambition. And I think this is really important. This isn't somebody who has said, I fundamentally disagree with this decision because it's against the public interest. This is somebody who has done it for his own personal ambition because of the crisis that exists in this government. In any event, I don't think there's any question at all, no ifs, no buts. This matter has to go to the police, and in that event, will my right honourable friend undertake that the government will fully cooperate at all levels, all ministers, all aides, all officials, including special advisers, in that police investigation which is now critical?
Minister.
Mr. Speaker, if the police consider that an investigation is necessary, then the government at all levels, ministers, officials and special advisers will give full cooperation.
Sir Edward Lee.
In this country, we believe in natural justice. In any company, the civil service, anywhere else, if you are accused of a disciplinary offence, let alone a criminal offence, you are given a chance in an impartial forum to prove your innocence. As a matter of natural justice, how is the former Defence Secretary now going to be given an opportunity to prove his innocence?
Very good. Minister.
I mean, I say to my right friend that my right friend, the member for South Staffordshire, has not been accused of any criminal offence, but sadly he has lost the confidence of my right honourable friend, the Prime Minister. Therefore, she has acted in accordance with the principles set out in the Ministerial Code.
Chris Bryan.
It's difficult not to sympathise, to be honest, with the former Defence Secretary, because in a kangaroo court you can't prove yourself innocent. That's what a lot of us are worrying about. And if he has done what is alleged, then of course he should face the full criminal law. But the Secretary of State is completely wrong when he says that it's nothing to do with the Attorney General. The Official Secrets Act states quite categorically that a prosecution can only proceed if the Attorney General allows it to. And any member of the public can go to the police and demand that there be a full investigation, and I suspect lots of people will. So has the Attorney General's advice already been sought? And how will the former Defence Secretary be able to make his representations to the Attorney General?
The honourable gentleman is mixing up a number of different things. The Attorney General's consent is required to prosecution under the Official Secrets Act. The Attorney General has no power to initiate an investigation or a prosecution. He is also, Mr. Speaker, continuing to confuse 2 points. What we are dealing with here, at the heart of the issue and the decision coming before the Prime Minister yesterday evening, was not so much the substance of what has been disclosed, but about the fact that the leak was of proceedings of the National Security Council, and therefore whether or not the various harm tests under the Official Secrets Act were met in this particular case. The Prime Minister came to the decision that regrettably she no longer had confidence in my right honourable friend, the member for South Staffordshire. That is why she came to the decision that she did in her assessment of the public interest.
The right honourable gentleman, the member for New Forest West, looks as though he was about to start a sprint. And I think he must be heard. Sir Desmond Sway.
Thank you, Mr. Speaker. Outside this House, a right honourable member is being called a liar. And inside this House, a number of honourable members have implied as much. Natural justice demands that the evidence be produced so that his reputation can be salvaged or utterly destroyed, doesn't it?
Minister.
I have taken great care, I think, Mr. Speaker, in the language that I have used in the House today, and I'm not in the business of going around making allegations of the kind that apparently have been made outside the House. But the fact is that my right honourable friend, the Prime Minister, came to the conclusion, having read the investigation report, that there was compelling evidence to suggest responsibility on the part of the former Secretary of State for Defence for the leak that had taken place from the National Security Council, and that was the reason she took the decision she did.
Andrew Stevens.
Thank you, Mr. Speaker. The Prime Minister herself, as Chair of the National Security Council, is ultimately responsible for the security and the integrity of its meetings. Does the Minister agree, yes or no?
Hence her actions yesterday.
Steve Baker.
Mr. Speaker, of course the principles of good governance must be upheld, but does this mark a turning point so that in future we will not see, I think further to the question from my right honourable friend for Beaconsfield, we will not see breaches of ministerial collective responsibility which undermine our negotiating position as we leave the EU?
Minister.
I sincerely hope, Mr. Speaker, that all ministers will abide by the principle that you speak with complete frankness in trying to shape and take decisions about collective government policy, and then when you leave the room, you support that government policy and you do not disclose details of the various arguments and debates that may have taken place in Cabinet or Cabinet Committee.
Mr. David Hanson.
I don't know, Mr. Speaker, whether the Right Honourable Gentleman for South Staffordshire has undertaken a leak or not. I'm not party to that information. But I do know, having sat on and sitting on the Intelligence and Security Committee and being subject to the same official secrets and the same briefings that ministers get, that if I had leaked at that committee, I would be subject to a criminal prosecution. So my question to the Minister is simply this. Did the Cabinet Secretary's report and has the Prime Minister's assessment at any time crossed the criminal threshold, and at any time has the Minister reported to the police, as any crime would do if it appeared at a business or personal premises?
Minister.
I mean, clearly, if there had been evidence to convince the Cabinet Secretary that a crime had been committed, or prima facie a crime might have been committed, he would have reported that to the Prime Minister, and he would have come to a different judgment about whether the government needed to refer this matter to the police. The decision that the Cabinet Secretary came to was that this matter did not need to be referred to the police. And there is a difference, to take up the Right Honourable Gentleman's initial point, between the tests for criminal offences that are set out in great detail, as he will recall, in the various clauses of the sections of the Official Secrets Act, and falling below the standards of confidentiality and other conduct that are required of government ministers under the Ministerial Code.
Greg Hands.
There are a few troubling aspects of this affair, to put it mildly. The Cabinet, I think we've seen, most would agree, there's been a number of leaks from the Cabinet as a whole, particularly in the last 2 years. Yet those leak inquiries either don't seem to have been pursued or to have not led anywhere. There's an impression given that a leak from the Cabinet might be okay, but a leak from the NSC isn't, and I think we have to be very careful to avoid that. My reading of the Ministerial Code is I don't think it even mentions the NSC in the Ministerial Code as being a higher level of proprietary. Can I ask my right honourable friend if there's any proposals to change the Ministerial Code in this regard?
Minister.
Well, the National Security Council, because it is constitutionally a committee of the Cabinet, would automatically be covered by the provisions of the Code which apply to the Cabinet and all Cabinet committees. The particularly serious nature of this leak derived from the fact that it is inherent in the nature of National Security Council discussions and of the papers going before National Security Council that the very highest degree of secrecy needs to be maintained. But my right honourable friend's point about the need for higher standards as regards Cabinet and Cabinet Committee meetings is also well made.
John Cryer.
Thank you, Mr Speaker. The Minister just said that the former Defence Secretary is not accused of committing a criminal act. If he broke the Official Secrets Act, then he is accused of committing a criminal act. Can you now answer the question that's been asked 3 times and he's failed to answer? Has the advice of the Attorney-General been sought or not?
Minister.
As I said in response to an earlier question, Mr Speaker, the role of the Attorney-General under the Official Secrets Act is not to authorise or initiate investigations. It is to give or withhold consent for a prosecution if and when a finished case is presented to him.
Victoria Prentice.
Thank you, Mr Speaker. I know from sitting firmly on the other side of the official ministerial divide how hard it is to get officials, let alone our allies, to share important and in particular secret information with ministers at all. Would my right honourable friend agree that what matters here is that we protect the integrity of the National Security Council if it is to operate at all properly?
Minister.
Yes, I agree wholeheartedly with my honourable friend.
Dr Sarah Wollaston.
How can this matter be closed as far as our security partners are concerned, given that the member for South Staffordshire has said that he is innocent? Can I ask the Secretary of State whether at any point he has been interviewed under oath, at any stage during the investigation? Because I note that he is not here to set out his position on the floor of the House. And I think it's absolutely vital for our security partners now to have confidence. If it wasn't the former Secretary of State for Defence, who was it? Who was it? Good.
I think our security partners can have confidence that the Prime Minister has acted swiftly and resolutely to uphold the essential integrity and secrecy of National Security Council proceedings.
Mr Peter Bone.
Thank you, Mr Speaker. First of all, I think it's regrettable that the Deputy Prime Minister didn't offer to make a statement to the House, but they had to respond to an urgent question. Also, that he is not, sir, giving away information that members are requesting. The former Secretary of State has said that on the lives of his children that he did not leak the information. This seems to have been a kangaroo court reaching a decision in secret which we have no evidence to base any decision on. So you will remember what happened to the Right Honourable Member for Sutton Coalfield when there was a rush to judgment. He was forced to resign and it was proved what he was saying was true. Is the Deputy Prime Minister absolutely sure, without any reasonable doubt, that the former Secretary of State is guilty, or could it just be possible that the kangaroo court has made a mistake?
Minister.
Mr Speaker, there was a thorough investigation. Every ministerial member of the National Security Council and those officials and special advisers who might have had access to material relating to the proceedings of that particular meeting was spoken to, and as the Prime Minister's letter yesterday made clear, cooperated fully with the investigation. The investigation report was presented to the Prime Minister by the Cabinet Secretary. My right honourable friend came to the conclusion, having studied it, that there was compelling evidence to suggest responsibility on the part of my right honourable friend, the member for South Staffordshire, and she took into account, as she said in her letter to my right honourable friend yesterday, that there was a difference in the findings of the investigation between the conduct surrounding the investigation of my right honourable friend and his team compared with the conduct of other ministers and their teams. That is why she came to the conclusion she did. But I repeat, Mr Speaker, that this comes back to the question of ministers serving in office so long as they retain the confidence of the Prime Minister. That is a principle that applies to every government in this country, and it is what applied in this case.
Alison Thunis.
Thank you, Mr Speaker. It is, by all accounts, now that the Defence Secretary is the 38th person to lose his job in this government that's riddled with incompetence and disloyalty. So it really is going something to actually be sacked by the Prime Minister. Yeah. So why is it that such a grave breach of trust, as has been described by the Prime Minister, has led to his sacking, but not enough to call in the police?
Minister.
For the reasons that I've given in response to a number of questions earlier, that the key issue here is less the substance of what was disclosed, but the fact that the disclosure was made in respect of proceedings of the National Security Council.
Mark Pritchard.
Thank you, Mr Speaker. Notwithstanding the particulars of this case, is it not time for the government to finally bring forward the espionage bill, which of course will include complete root and branch reform, long overdue reform of the Official Secrets Act? And despite the Deputy Prime Minister's comments today, is it also not the case that Cabinet leaks will continue as long as Cabinet papers retain the current classification that they currently do? Is it not time that we had a review of how Cabinet papers are classified, and all of them should be classified secret and above?
Minister. Well, obviously, questions of the classification of documents are kept under review the whole time, although in my recent experience, there have been some Cabinet papers that have been classified at secret level, but others at lower level. It depends on the substance of what is included within those papers. In terms of my honourable friend's question about future legislation, obviously we are keen to bring forward the measure to which he referred and other bills to this House as soon as we can.
Mike Gapes.
Mr Speaker, clearly the former Secretary of State for Defence thought it was his way or the Huawei, and he has been told by the Prime Minister to go away, but he hasn't shut up. Isn't the reality that we will not get the truth unless there is a resignation or sacking statement by the former Secretary of State to this House and a chance for us to debate it and get to the bottom of this fiasco?
Minister.
Mr Speaker, it's a matter for my right honourable friend whether he wishes to apply to you to make a personal statement, but obviously there has been a public exchange of letters between the Prime Minister, my right honourable friend, the Secretary of State for South Staffordshire. I would just say that the Prime Minister came to her decision for the reasons that she has given, and I've tried to set out to the House this morning. I think that on her part, her sense that this decision was necessary was accompanied by a sense of real sadness, because this is not a decision, I think, that any Prime Minister would take lightly and not without considerable regret.
Bob Blackman.
Thank you, Mr Speaker. The National Security Council is a relatively modern phenomenon, and clearly my right honourable friend has set out some of the issues that the body has actually discussed. The clear concern, I think, of the House, however, is this. If the right honourable member for South Staffordshire is not responsible for the leak, which he says he's not, then someone within the National Security Council is. And therefore, it is absolutely vital, I think, in most people's view, that there is an independent police investigation to demonstrate whether he is guilty or not.
It's obviously for the police to decide whether they believe that this case merits a police investigation, but it's not the job of the police to conduct leak inquiries of material disclosed within the government. There is an established system for doing this, and as my right friend the Prime Minister set out in her letter to the former Defence Secretary, she concluded that there was no alternative explanation to this particular leak that she found credible.
Ben Lake.
Mr Speaker, the events of the past week have brought into sharp relief both the importance of handling such sensitive information responsibly, but also the perception that it is undertaken securely. And with this in mind, can I ask the Deputy Prime Minister for his reassurance that if the government had concerns that the Official Secrets Act may have been broken, that it would be referred to the relevant authorities?
Clearly, the Cabinet Secretary, in coming to his judgment, made a careful assessment of those matters, but the judgment is that this is not something that the government should refer to the police. Prime Minister does consider the matter now closed. And again, Mr. Speaker, I repeat, it is the fact that this was a disclosure from the National Security Council that was at the heart of the seriousness with which this matter has been taken.
Mr. Simon Hoare.
Thank you, Mr. Speaker. Can I welcome what my right honourable friend has said, and flowing from it ask him two questions. First of all, can you confirm that it is not naive or misplaced to still believe that we have a senior civil service which is imbued with integrity and probity, and that we can rely upon? And the second point, following on from my right honourable friend, the member for Sevenoaks, we know that the security and intelligence family is a close one, and like all families rely upon that mutual relationship of trust. Can my right honourable friend assure me in the House that rather than just taking for granted that our allies consider that we are still trustworthy and steadfast, we will go out proactively and positively and reaffirm that case, because not to do so would clearly put our country at risk?
Minister.
Mr. Speaker, I would say to my honourable friend, yes, I am very confident in the fact that we have an impartial, professional senior civil service that will serve and is always ready to serve the elected government to the best of its ability, whatever political stripe that elected government bears. Secondly, I think that it is actions rather than words that will demonstrate to our allies on security and intelligence matters that they should continue to trust us, and just as we look to their actions when there are reports of things going wrong within their systems. But it is absolutely right that we need to act swiftly and be clear about taking action to put right any flaws in our system of the kind that we've experienced with the NSC in the last couple of weeks.
Tommy Shepherd.
Mr. Speaker, given this has never happened before, isn't the real question here, how can it be that the former Defence Secretary, or indeed anyone else, has felt so emboldened and confident to leak confidential information now? And isn't the answer to that, in large part, that this government is so fractured and weakened that it has lost the authority and cohesion to be able to govern, a process that will now be compounded by the government beginning to eat itself alive in the search for a new leader? So isn't the real way to guarantee that this doesn't happen again for the government to put itself out of its own misery and call a general election?
Minister.
It takes a bit of brass neck, Mr. Speaker, for a member of the SNP to talk about fights between party leaders, but the truth is, Mr. Speaker, that the Prime Minister has taken very firm and swift action in response to the leak investigation that was carried out on her instruction, and the government is getting on with the task of developing policies designed to protect and enhance the national security of the United Kingdom in respect both of the safety of our citizens and the defence of our interests around the world.
Mr. Philip Holloway.
All members of the National Security Council have sworn the Privy Council oath, and top-secret material is circulated and discussed. If a leak of information from the National Security Council isn't a breach of the Official Secrets Act, what is?
The various tests for a criminal offence are set out in detail in the Official Secrets Act, and whether or not that threshold has been breached depends on harm tests, and those harm tests are different depending on what category of information, the contents of information we're talking about.
James Cartledge.
Thank you, Mr. Speaker. Surely one risk of this leak is that it effectively predetermines the public mood on the substantive issue of why, in a more hawkish fashion. before we have come to our own policy conclusions. And so can I say to my right honourable friend, of course the Five Eyes are our most important allies and we have to do everything we can to reassure them, but we are also a sovereign country. We have our own unique circumstances and our own more nuanced position with Beijing. And so can I urge him to continue all of the work across Whitehall in a calm and deliberative fashion, but above all in an objective fashion, so that we come to the right policy on the point of substance.
I'm grateful to my honourable friend for those comments, and he's right. And it is vital in carrying out that work that we have a forum in the National Security Council where the intelligence chiefs can talk frankly to ministers about their assessment of the balance of risks and threats that this country faces, and where ministers, taking account of the best advice available to them, can weigh up how to strike the right balance between this country's future and developing security interests, our future and developing economic interests, to try to steer a way forward that delivers the best outcome for the people of the United Kingdom.
Thank you, Mr. Speaker. Should any evidence or confirmations by individuals involved in writing up this story come to light, disproving these allegations, what would the consequences or the implications of that be?
Well, my honourable friend's inviting me to engage in a bit of hypothetical speculation, but I would say if there were to be any such clear evidence, then I think the Prime Minister would want that reported to her immediately and given to her in full. That would clearly need to be the provision of information that provided some other credible explanation for the leak that has taken place.
Bob Seeley. Thank you very much indeed, Mr. Speaker. I hold the Secretary of State in very high regard. Last week, during PMQs, he implied that Huawei was a private firm, effectively arm's length from the Chinese state, as one of our own firms would be. Isn't it the case that that is, at best, a half-truth? That Huawei is effectively 99% owned by Chinese trade unions, that is effectively being part of a one-party state, and therefore Huawei is effectively an arm of the Chinese state.
Huawei, and to the Huawei point, Huawei is officially owned by its employees and is a private Chinese company. It is true, as I think I said at the Despatch-Box, I've certainly said on previous occasions, as have other ministers, that there is an issue wherein the Chinese law requires all Chinese companies to cooperate with the Chinese state. But as I said earlier, Mr. Speaker, in response to another question, the review of 5G goes beyond a single company or a single country, because what we need to do is to make sure, amongst other objectives, that we have a diverse marketplace so that the government has a genuine choice of suppliers available to it.
Thank you. Yes, well, I'll take the points of order on the assumption, which I would like to think is safe, that neither member would seek to continue the debate that we've just had. I feel sure these are matters of order, and that the honourable gentleman from the front bench will focus with a laser-like intensity on that matter. Mr. Tom Watson.
Mr. Speaker, in his answer to me earlier, the Secretary of State said that the matter for the police, the matter to investigate a criminal act, is a matter for the police, not for ministers. Can you assist me what remedy there is if I think he may have inadvertently misled the House on that? Whilst we have been in the chamber, the Metropolitan Police have told ITN News that the matter to investigate is a matter for the Cabinet Office, and if they share the information with the police, they will investigate, but they won't investigate unless the information is shared. Will the Deputy Prime Minister clear this matter up? Is there a way he can do that? Perhaps he could agree to share the information with the police from the Despatch-Box.
Well, the honourable gentleman, as I think he knows, has found his own salvation. By means of the attempted point of order, he has registered his point, and he's placed on the record information which may have been known to some members, but, for example, was certainly not known to me, because I've not been consulting electronic devices, but merely attending to my duties in the chair. If the Minister wishes to respond, he's free to do so, but there is at this point no sign of him uncoiling. But I know the honourable gentleman, is a dogged terrier, and I feel sure he and others will pursue these matters if they feel so inclined in the days ahead. A former Rottweiler, he says, I'm not sure I see the appropriateness of the inclusion of the word former. And point of order, Mr. Stewart Malcolm Mcdonald.
Mr. Speaker, further to the point of order from the shadow front bench, in response to the Right Honourable Member for Gainsborough, the Deputy Prime Minister said that the Right Honourable Gentleman for South Staffordshire was not being accused of a criminal offence. But in response to my question, he said that that was not for him to determine. And given the further information just shared by the Labour front bench, both of those things don't stack up, Mr. Speaker. So I wonder if the Deputy Prime Minister felt he should, if you would indulge in coming to the dispatch box to clear up these issues that have been raised by myself and the Labour front bench.
Well, I would if he did, but he doesn't, so I won't. But I rather fancy that these matters will be explored further in the days ahead. Realistically, it doesn't seem to me that there's very obvious scope for the scrutiny of this matter further in the Chamber today. But who knows what subsequent days might bring. Let's leave it there for now, and we come now to the urgent question in the name of Mr. Alan Brown.
Thank you, Mr. Speaker, and thank you for granting the urgent question. So, to ask the Secretary of State for Transport if he will make a statement providing updates on the no-deal Brexit preparations for cross-channel ferry and freight services.
The Secretary of State for Transport, Secretary Chris Grayling.
Well, Mr. Speaker, as you're aware, the Government is now reviewing our contingency planning for a no-deal EU exit in the wake of the recent developments. No decisions have yet been taken for what will prepare for the new EU exit date of the 31st of October. Of course, many of the preparations that were made for the 29th of March are still in place, Mr. Speaker. The planning assumptions which underpin the original maritime freight capacity activity will need reviewing in the light of the Article 50 extension to understand if they are still valid. A collective view will then be taken across government as to the necessary contingency plans that will need to be implemented, including working closely with the Department of Health and Social Care and DEFRA to understand the needs of their supply chains. Mr. Speaker, you'll recall that in December we entered into contracts with ferry operators to provide additional capacity into the UK as part of no-deal planning. Those contracts were scheduled to run up until September. They were an essential insurance policy to ensure the continued supply of Category 1 goods, primarily medicines and medical devices for the NHS, in the event of a no-deal Brexit. As I've indicated to the House previously, the reason we took that step was a change to the modelling carried out across government, which indicated that flows across the short straits could fall significantly and, crucially, for significantly longer than had previously been proposed by our analysts. It would have been irresponsible for the government not to act as no deal was and remains the legal default. This was an insurance policy, and insurance policies are a prudent investment whether or not they are actually used. Following the Article 50 extension until the 31st of October, the Government has now decided to terminate the current contracts with Brittany Ferries and DFDS with immediate effect to minimise the cost to taxpayers. The termination of those contracts cost £43.8 million. That's lower than the NAO's estimate of the total termination costs. And I should say, Mr. Speaker, that represents around 1% of the overall £4 billion package of no-deal EU exit preparations, which this Government has wisely taken to ensure we are ready for all eventualities.
Alan Brown.
Thank you, Mr. Speaker. Mr. Speaker, I do wonder if we ever get to the bottom of this whole mess, and truthfully, the Secretary's statement there doesn't give us any more clarifications in terms of what the Government's doing in terms of no-deal preparations. Now, initially we were told that the initial contracts were part of emergency procurement for the unseen scenario of a no-deal Brexit, despite us being assured that the Government had actually prepared. Then we're to believe the logic in handing an emergency service contract to a company with no ships and no financial backing. Then an urgent question with the Health Minister advising us that these contracts were needed for shipments of priority goods such as medicines. The Secretary repeated that in his statement. So if that was the case, why did these contracts automatically kick in March the 29th and not actually be linked to an actual no-deal scenario whenever that no-deal exit happens?
What exactly did these contracts procure, and why is it taking a month for the latest contracts to be reviewed and then cancelled at this cost of £43 million? What is the government doing in terms of the next possible no-deal Brexit date of October 31st? Because it's quite clear planning needs to happen now if the previous contracts had to be entered in December for a March kick-in date. So it's obvious the government should be working on this right now. In the emergency debate that was granted, Mr Speaker, in terms of these contracts, I asked about the possibility of further legal action, and the Secretary of State assured me that there would be no further legal action. I said at the time, I hae my doubts, is what I said. So it comes as no surprise that we now learn that P&O ferries are suing the government. So when did the Secretary of State find out about P&O's intentions? Where has that got to? Is it going to go through the courts, or is it going to be a cave-in and another £33 million settlement? Now, Mr Speaker, I know that governments do not normally publish legal advice, but we're clearly in exceptional circumstances with these turning events. So will the government actually provide or publish the legal advice they've had over this period of time? What independent reviews is the government taking to understand the blunders that have happened and actually learn lessons from this so it doesn't happen again? Now, the Secretary repeated what the Minister said earlier on, that this £43 million cancellation of ferry contracts is only 1% of the Brexit preparation costs, as if it doesn't matter. In actual fact, these ferry contracts overall are going to cost probably up to £120 million, depending on the P&O settlement. So when does somebody become accountable for this waste of money? It's not negligible money, it's a lot of money. Mr Speaker, many people ask me, why is the Secretary of State still in post after all his blunders? I can't answer that, but I would ask that he does the right thing and finally take responsibility and step aside.
Mr Speaker, as usual, we've got the customary stream of nonsense from the honourable gentleman opposite. I have no intention, first of all, Mr Speaker, this has been and will continue to be scrutinised by the National Audit Office, who are the appropriate people to do so. I'm not going to comment on ongoing legal matters, except to say the Government vigorously disagrees with P&O and will defend it to the hilt. I really, though, don't think, Mr Speaker, you either listened to what I was saying today or has been listening the last few times I've talked to this House about this. The fact is he's disagreed all along with the steps we've taken. But if I could just read to him a small excerpt from a letter I received last month, which said, my officials have also asked that critical exports should be given priority access to the additional ferry capacity secured by the UK Government where this is not required for essential supplies. That request, Mr Speaker, clearly recognising the need for that capacity, came from the Cabinet Secretary, the Cabinet Minister in the SNP Scottish Government.
Sir Desmond Swain. But we wouldn't have had to spend the money if the honourable gentleman's party opposite had voted for the agreement. But is my right honourable friend looking forward to the return of duty-free on the ferries as much as I am?
Well, Mr Speaker, it's very much my hope we do reach an agreement and the duty-free won't be necessary. I'm sure if it becomes necessary, he may have that opportunity. But he makes a good point. So members across this House who complain about the money that we've rightly spent on an insurance policy against a no-deal outcome, the way of preventing that money being spent would have been to vote for the deal. And parties opposite have systematically refused to accept that what is before this House and has been before this House is a sensible deal to deliver a sensible future partnership with the European Union. It is just a shame that they've always been unwilling to accept that.
Andy Mcdonald.
Mr Speaker, on the 5th of March, I told the Secretary of State that his settlement with Eurotunnel risked further litigation from other companies. I warned that taxpayers could face more compensation bills in the tens of millions of pounds, and I was dismissed. But I was right and he was wrong. His department is now facing legal action from P&O Ferries, and this all flows from his decision to award a contract to Seabourn Freight, the ferry company with no ships. The Secretary of State bypassed procurement processes to award contracts, rules that were put in place to prevent this sort of waste of public money, and awarded a contract that was in breach of UK and EU public procurement law. As a result, he made a potentially unlawful £33 million settlement with Eurotunnel, promoting P&O to take legal action. Who made the decision to bypass procurement rules? Was it the Secretary of State, and does he accept responsibility? The Transport Secretary should have recognised his Eurotunnel decision risked further litigation. Why did he dismiss my concerns, and was he poorly advised? And yesterday we discovered that the department must pay around £43.8 million to cancel no longer needed ferry contracts. Given the entire Brexit process has been characterised by uncertainty, why didn't the Transport Secretary negotiate contracts that could be delayed if the Brexit date was delayed? If he had, he could have avoided this colossal waste of money. And what is his estimate of the total cost to the public of his no-deal contracts? Mr Speaker, every other week MPs must debate the Transport Secretary's latest costly blunder. I'm afraid that this will continue so long as the Secretary of State remains in post. Mr Speaker, this country can no longer afford the Secretary of State.
Well, Mr Speaker, it's just indicative that the Labour Party did not believe, does not support the need for this government and this country to make sure that in all circumstances the National Health Service receives the drugs it needs. And I'm afraid that is just irresponsibility on his side. Now, he raises various questions about this. He mentioned seaborne freight. The legal action with Eurotunnel had nothing to do with seaborne freight because the contract with seaborne freight had been terminated several weeks before, after they had secured ships, but when their principal financial backer withdrew. I bypassed no processes. These were done properly in accordance with government procurement rules. They have been vetted and looked at by the National Audit Office, who already provided one report on this. This was a collective decision by government to make sure that we could look after the interests of the National Health Service, that we took the right insurance policies in the event of a no-deal Brexit, and we will continue to take the right decisions and the right insurance policies if there continues to be, which I hope there won't be, a risk of a no-deal Brexit.
Mr Peterbone.
Thank you, Mr Speaker. I don't see how the House can blame the Secretary of State for believing the Prime Minister when she said on 108 times that we were going to leave on the 29th of March. And when her withdrawal agreement was defeated 3 times in the House of Commons, it would have been negligent of the Secretary of State not to have planned for a no-deal Brexit. The one thing for sure is the Secretary of State can't be blamed, maybe the Prime Minister can. And would the Secretary of State agree with me? A lot of people are making political points based on no evidence whatsoever.
Well, this is absolutely the central point. This process was carried out properly in the context of the legal advice that was available, in the context of the needs elsewhere in government. My department never needed any ferry capacity. This was procured because other departments did. If further contracts are let in the future, it will be because other departments need for services like the National Health Service. The party opposite seems more interested in trying to score political points than actually supporting securing drug supplies for the National Health Service.
Tom Brake.
Speaker, on the 11th of February, column 623, the Secretary of State said in response to my question, re the ferry procurement, I have been absolutely clear that this procurement was dealt with very carefully by officials in my department and in the Treasury. Now, whilst the Secretary of State may believe this matter was dealt with very carefully, I think the rest of the world believes otherwise, and that in fact he's reached dizzying new heights of incompetence. The Secretary of State's latest bungling has cost an extra £43 million on top of the £2.7 billion he has cost us so far. But if the P&O win their case, how much more is the Secretary of State going to cost the taxpayer? And will that be the point at which the Secretary of State finally accepts that he has no choice but to resign?
Well, I know the honourable gentleman doesn't believe in Brexit. He clearly doesn't believe in no-deal preparations. And he clearly didn't listen before when I said what I said. We took decisions. I have set out exhaustively in this House why we took the decisions we did, why we responded in the way that we did to the legal advice that we had, and we simply took steps to make sure that we were ready for a no-deal Brexit. The responsible thing to do, he might not agree with it, but that's what we've done.
Chris Davis.
Thank you, Mr Speaker. What steps has my right honourable friend taken to reduce the amount that had to be paid to the ferry companies involved?
Well, I mean, it's an important point. We have paid a reduced cancellation charge, as set out in the original contract, if we did not need, as a result of a changed circumstance. And the changed circumstance, of course, is that the potential no-deal date has moved by 7 months. And nobody seriously expects we would be paying to have ships either sailing empty or moored at the quayside for that time. But, of course, the companies incur costs by leasing extra ships, taking on extra staff, which has to be met. What we negotiated at the start was a cancellation level of payment that meant we didn't have to pay the full amounts of the contract and mitigated the cost to the taxpayer of the insurance policy we took out.
OK, that's great.
Jay Stevens.
Thank you, Mr. Speaker. The private sector has no faith in the Department of Transport's ability to undertake procurement properly. Confidence has been lost. So is the Secretary of State not concerned that his own incompetence will reduce future private sector investment in the transport sector?
Well, I don't know what she's talking about, but she's not specific. I'm not aware that he says the private sector has lost confidence in the Department's procurement. That tends only to be the case if people haven't won contracts.
John Howe.
I have continuously voted for the deal, as the Secretary of State knows, and the insurance policy is there to protect both exports and imports to the UK. So I fully accept what he's saying about that, but I wonder whether he would join me in trying to get a change to the procurement rules so that they include a substantial element of alternative dispute resolution to make the whole thing cheaper and quicker.
Well, absolutely. I mean, I regret that anybody, any big company, particularly in the case of Eurotunnel, they would take a decision to pursue a legal action at a time like this when the government is seeking to operate in the national interest. But the law is the law. And we have to fulfil it. And I absolutely agree with my honourable friend that alternative dispute resolution is a good way, when it can be delivered, of resolving things.
Gavin Jones.
The criticism isn't that preparation shouldn't have been made. The criticism is of the way in which these contracts were actually awarded. Now, the Secretary of State is doing his usual trick of standing back and saying he's the innocent bystander in this. So is he actually saying that he just followed the advice of his officials and signed this off? Or did he actually intervene and overrule, especially, for example, the seaborne freight contract, to ensure that they were awarded a contract? Or is he just going to hide behind what we've got with the train timetables idea? It's somebody else's fault, Gov, not mine.
Categorically say, Mr. Speaker, I've not intervened in any matters relating to the decisions to let these contracts, how they were let and what the recommendations were about letting them.
John Bercow.
Thank you, Mr. Speaker. Does he share my frustration with those in this House who I think wrongly rant that a no-deal Brexit